Life aboard says follow procedure, keep your nose in line. The department says new circular, change it all by 9. The patron says remember now, uphold the ethos true. 3 sets of rules before the bell, and all of them askew. Oh, I got 3 bosses and they don't agree. One says stop, one says go, one says pray quietly. I teach the kids, but who teaches me how to survive this legal trinity?
Hello, hello, hello. Declan O'Lula, QC here. And today we tackle a question so niche, so peculiar, so gloriously Irish that only teachers ever ask it. And yet, it's one of the most legally bizarre employment structures in Europe. Because as a teacher in Ireland's national schools, the person who hires you is not the person who pays you, and may not even be the person who controls your job. Yes, it's less an employment relationship and more a legal love triangle. And like all triangles, it ends in confusion, litigation, and someone crying in the staff room. Let's begin.
Right. First principle. Teaching in Ireland is not a normal job. In most jobs, employer hires you, employer pays you, employer fires you. Simple, civilized, predictable. But teachers? Ah, no. Instead, we have what lawyers call, after a few drinks, a tripartite employment relationship. That's the teacher, the Board of Management, the state, in the shape of the Department of Education. 3 players, 1 job, infinite confusion. Historically, this mess didn't happen by accident. It evolved because schools were run by religious patrons, usually the parish priest. The state slowly took over through funding and increased regulation, but never quite took responsibility. It was a classic Irish solution. We'll control everything, but employ nothing. All that power with no responsibility.
Now, where do teachers' rights actually come from? You'd think, the contract. No, that's just one piece of the legal lasagne. Teachers' employment conditions come from contract law, statutes like the Education Act 1998, EU law, and, my personal favorite, department circulars. Circulars, which sounds harmless, like something you'd ignore in school. But legally, they are terrifyingly powerful. They dictate pay, leave, discipline, recruitment. And courts have said quite clearly, if you ignore them, your decision can be legally void. So yes, your contract might say one thing, but a circular issued on a Tuesday afternoon can ruin your week.
Now we get to the juicy bit. Who actually employs the teacher? On paper, it is the Board of Management. This is supported by the Education Act 1998 and judgments like Murphy versus Minister for Education, which we will discuss later at length. In reality, the board hires you, disciplines you, fires you. So far, so employer. On the other hand, the state pays your salary, sets your conditions, controls the numbers of teachers. Which raises the obvious question, if it walks like an employer, pays like an employer, controls like an employer, is it an employer? What do the lawyers say? They say, well, it depends. Of course it does. Let's embrace the chaos. Here's the reality. You are simultaneously employed by the board, paid by the state, influenced by the patron, until quite recently, always the priest. It's not a line, it's a triangle, and each corner pulls in a different direction. Board, we manage you. State, we fund you. Patron, we define the ethos. And you, the teacher, are stuck in the middle thinking, who do I sue? A fair question. and one the courts have wrestled with repeatedly.
Enter our hero, or victim, Ms. Boyle. This case started out as Boyle versus Minister for Education. Now this case is like a legal soap opera. Let's break it down. Ms. Boyle complains to the Rights Commissioner in terms of the Protection of Employees Part-Time Work Act of 2001, as she is not allowed entry into the contributory pension fund like other teachers in her position. In order to qualify under that act, she needs to be an employee, and therefore she needs an employer. In January 2011, the Rights Commissioner decided that the minister was her employer. The basis of the Commissioner's reasoning was that the state controls everything, and the control test is a critically important test when deciding whether there is an employee-employer relationship. The minister appealed the decision of the Rights Commissioner to the Labor Court. In July 2012, the Labor Court confirmed the reasoning of the Rights Commissioner and found that, yes, absolutely, the state is basically running the show. At this point, the minister is sweating. He appeals that decision to the High Court, both on a point of law. He challenges the Labor Court's interpretation of the 2001 Act, and by way of judicial review, he argues that the Labor Court had no authority to place Ms. Boyle on the pension scheme. The High Court considered the facts of the case, the historical context, the case law, the Constitution, and the relevant legislation. On 19th July 2016, the High Court found that the minister was Ms. Boyle's employer, but agreed that the Labor Court acted ultra vires when it put Ms. Boyle on the pension scheme. By now, the minister has visions of his head stuck on a stick in the Doyle pub, and in desperation, appeals to the Court of Appeal. On 24th February 2017, the Court of Appeal found that despite the fact that there was no express contract of employment, there was an implied contract as the minister paid her wages and fitted into what the 2001 Act envisaged as an employer. The court held that it seems idle to deny that as a matter of reality, the minister was in substance the employer of Ms. Boyle. The court held that although the minister did not control Ms. Boyle in the traditional sense, the control test was simply one factor that they looked at in defining the employment relationship. And there were just too many other factors pointing to an employer-employee relationship. At his stage, the minister's political career is in free fall, with large flames blossoming out the tail. He goes for one more throw of the dice and appeal to the big boss, the Supreme Court. The Supreme Court held on 1st November 2018 that the essential question before it was whether the unusual relationship which exists between a teacher, a board, or committee of management and the minister can properly be construed as involving, at least in part, a contract of service between a teacher and the minister. The Supreme Court emphasized the control aspect of the employment relationship and said it was noteworthy that the minister had no right to direct the type of work that Ms. Boyle should do, and this negated the existence of a contract of employment. The court upheld the minister's appeal essentially on the strict wording of the 2001 Act, which was different to other employment statutes. Now, before you relax and say, "Ah, sure, that clears it up." Nope. The Supreme Court went on to say that there may well be circumstances where a minister may incur liability in respect of persons whom a minister chooses to pay directly, or where the minister is the effective paymaster even though the payment may be made by an intermediary. In other words, depending on the facts and the applicable statute, if any, there might be instances where the minister can be held to be the teacher's employer. Talk about leaving it on a cliffhanger. But importantly, as the volume and weight of circulars seems to be on the increase, it might soon be possible to argue that the minister is now in effective control of what teachers can and cannot do. The Supreme Court also said the system is still triangular. So we end up with the board is the legal employer, with the power of dismissal, responsible for day-to-day control, usually through the principal. The state pays you, controls conditions of employment, sets rules. The result, a hybrid system where nobody is fully in charge, but everyone, apart from the teacher, has power. This isn't just academic misery. It matters enormously. Because when things go wrong, like an unfair dismissal claim, who's liable? The board. A pupil brings an equality claim. Sometimes, the state gets dragged in. A parent sues for negligence, vicarious liability, which is where the employer is held liable for the employee's actions at work. Usually, the board pays, except in cases like O'Keefe versus Ireland, where the state was found to have a non-delegable duty, which is legalese for, you can't just wash your hands of this. So even when the state isn't officially the employer, it's not entirely off the hook either. Confused? Good. My job is done. Courts, in fairness, are trying to keep the show on the road. They respect the autonomy of schools, enforce strict procedures, protect teachers' rights. But they are also deeply reluctant to say all teachers are state employees, because that would cost a fortune, collapse the current system, cause administrative carnage. So instead, courts take a very Irish approach and say, we'll deal with it case by case, which is legalese for what the fudge? So what have we learned? In Ireland, your employer is the board of management. Your wages come from the state. Your working life is controlled by both. And the law? It pretends this makes sense. The reality is that power is shared, responsibility is blurred, and litigation is inevitable, which frankly keeps people like me in business.
If you're a teacher watching this, good luck. If you're on a board of management, God help you. And if you're the Department of Education, we see what you're doing. I'm Declan Olula, QC, and remember, the law is not always logical, but it can be entertaining.